Hi, Attorney Rob Wells here, and in this video we're going to talk about the new statewide eviction control statute in AB-1482. Hi everyone, this is Attorney Rob Wells with you from the Law Office of Robert Wells, and in this video we're going to talk about California's new statewide eviction control overview. In this video, we're going to explain to you what the new AB-1482 bill that just passed in September of this year is going to do as of January 1st of 2020. As an overview, this new bill adds Civil Code sections 1946.2, 1947.12, which is the rental price control provisions of AB 1482, and less important, less relevant to most of our clients will be the 1947.13 section to the Civil Code that will be added. Long story short, it's basically an exemption for owners that build ultra low housing. There's an exemption for those owners for sections 1947.12. So in this section we're going to talk about, particularly we're going to focus on sections 1946.2, which adds a new civil code section that regulates certain owners and property managers about how they can initiate evictions for protected residents. And as I said before, all these code sections will be in effect as of January 1st, 2020. So let's just go over an overview real quick. I wanted to highlight the reasons why people can be evicted in California. Fortunately, all the code sections aren't in one particular place, but we'll give you an overview of them briefly so you can understand how these restrictions will play into effect. Pretty much for month-to-month tenancies, under the existing 1946.1, a landlord can issue a 30 or 60-day notice if a tenant's resided at a property for more than a year or more without any cost. The landlord can do it for any reason but for an illegal reason, such as retaliating against a tenant for exercising a lawful right, discriminating against race, and so forth. Your Civil Code 789 covers tenancies at will, which is a tenancy that has no payment of rent. There's no contract to pay rent of some sort. So you got your friend that's couch surfing at your house, your adult kids living with you at home for free. Those evictions would go under the Civil Code 789 sections. Then you also have the Code of Civil Procedure 1161, which covers basically tenancy, evictions for cause. Basically, you don't pay your rent, your lease expires, and you fail to leave. You breach a material term of the lease and you don't fix it, or you're causing an illegal, an unlawful nuisance. You're selling drugs out of the property and so forth. And if a tenant gives you notice, let's say your tenant gives you 30 days notice to vacate and they fail to vacate, well, that's covered under 1161. You got your less frequent evictions under 1161A, which are evictions after sale, voluntary sales of property your owner doesn't leave, or foreclosures. Now, what the legislature did in September of this year, and it was signed into law by Governor Gavin Newsom, is add a new code section, 1946.2, which adds additional terms and conditions owners and landlords will have to comply with, and we'll cover those next. So, for my owners, my property managers, to make this very simple, make this 10-page bill a lot simpler, we're going to speak in generalities just so you can, follow along if the new law applies to you or not. And the major things that an owner or landlord needs to be aware about is 1946.2 only comes into effect when the owner meets a certain condition, and the tenants and or occupants of the property have to reside at the property for the requisite amount of time. And then at that point, eviction control would apply. So, and generally speaking, for 1946-2 to apply, the owner must be either a corporation, a real estate investment trust, or REIT, as defined under the Internal Revenue Code, the tax code, or an LLC with at least one corporate member. If you are a corporation or a REIT or an LLC that has a corporate member, generally most of the exemptions to 1946.2 will not apply to you, and for all your residential property, you'll be subject to it. We'll go over the exemptions in more detail, but just if you're an entity, you're probably not going to have an exemption. Or if you have a property with 2 or more units. For owners that rent rooms in single family homes, 1946.2 applies to you if you rent more than 2 rooms. And there may be an exemption for you if you share a bathroom or kitchen. We'll get into that in much greater detail. And this is the and. So if you're an owner and one of these situations apply to you, that's great. But again, all tenants and occupants must lawfully reside at the property for the requisite amount of time in the statute, which will cover for it. If you only have one of these elements, not the residency requirement, this won't apply to you just yet. But we'll go into more detail now. Okay, so like I said before, 1946-2 is going to apply to any real estate REIT or LLC that has a corporate member, any residential property that contains more than 2 or more units, and there are going to be several laundry lists of exceptions that may or may not apply to you, so to speak. So if you're one of these parties, great. You're on notice that this may apply to you, but if you have an exemption, that may take you out of the eviction control restrictions. We'll cover some of the exemptions right here. So, if you have one of these situations that apply to you, such as if you have housing built within the last 15 years and you have a certificate of occupancy that was issued within the last 15 years by your local municipality, great, you're exempt. Most single-family homes will be exempt under the statute as well, too. So as long as you're not a corporation, a REIT, or an LLC that has one corporate member, great. You are protected as well. So my owners that own their properties outright in their individual name, or even if they have an LLC and they're individuals that are members of that LLC, you will be protected. If you own a duplex where the owner resides in one unit, you will also be protected. Owner-occupied single-family homes where the landlord rents no more than 2 rooms, and that will include a granny unit, an accessory dwelling unit, etc. If you rent less than 2 rooms, great, you're protected. If you rent more than 2 rooms, you might not be protected as much. There's an exemption too for housing where tenants share a bathroom or kitchen facilities with the owner who maintains their principal residence. So maybe my folks that rent out a 3rd bedroom or a 4th bedroom in the property, you may be covered. You're probably covered under that exemption, but the legislature really never made that clear. I'm gonna, as the landlord's attorney, I'm gonna hang my hat on. If you share a kitchen facility or bathroom with your tenant, you're probably gonna be exempt. If you're an educational institution that runs a dorm operated by a college, university, or even a prep school at a K through 12 institution, you are protected. You are exempt from 1946.2. And you got housing that's operated by nonprofit hospitals, religious facilities, extended care facilities that have other licensing requirements from the state in that list there, you're going to be exempt. And then last but not least, transient and tourist hotel occupancies as defined in Civil Code 1940. So your Motel 6 type, motels that rent out rooms by the night, you're going to be exempt from this statute here. Other exemptions that apply to the new eviction control statute from California will be if your city or county or your local municipality has an eviction control statute in place prior to September 1st, 2019, you have to follow the local eviction control ordinance if it's in effect before September 1st of this year. And now if that ordinance is enacted after September 1st, 2019 or modified in any way, the law says that the local ordinance must be more restrictive than the provisions out in 1946.2. So for cities that want to enact their own eviction control that is less protective than state law, you're out of luck. You're going to have to be more restrictive than California's state statute. So just be aware of that. Now, I mentioned that there has to be a tenancy residency requirement, and here's how it works. So let's assume you have one tenant. That tenant has to continuously and lawfully occupy the property for at least 12 months. Now, if the named tenant in the rental agreement has lived there continuously for at least 12 months, and the owner is not subject to an exemption under 1946.2, then eviction protections apply, and we'll cover that in more detail, what that means. In summary, you can only evict a tenant for just cause. You can't just give a tenant notice to vacate on a 30 or 60 day notice like back in like what we used to be able to do, or for what owners that are exempt under this statute can do. We'll cover that in more detail. What happens if you add more adult occupants to the rental agreement? Well, 1946.2 then says either all tenants have to continuously and lawfully occupy the residential property for 12 months or more, or at least one of those tenants or occupants has to occupy the property for 24 months or more. That means either all your tenants have to reside at the property for at least 12 months, or you have to have one tenant that lives there at least 24 months or more. If you have that situation and you don't have an exemption to 1946.2, eviction control is going to apply. And we'll cover that next. So, what happens if you are subject to 1946.2? What does the law require you to do? Well, in non-rent control or eviction controlled areas, a lot of people aren't familiar with what just cause is. And in places such as San Francisco or Berkeley or Oakland, they usually have what's called a just cause eviction ordinance, and this is kind of what the state's introducing for the entire state if you fall under these provisions here. So in a sense, you can't do an eviction anymore for no reason at all. You have to state cause, and just cause is defined as, one of the following: the typical fault style eviction, like your tenant doesn't pay rent, their rent on time, or as agreed in the lease, or they breach a material term of the lease, like you're not supposed to smoke in the property, but your tenant's smoking. You're maintaining or committing or permitting a nuisance. Your tenant's dealing drugs or causing loud parties and disturbing the peace, that type of deal. Committing waste on the property, such as your tenant is literally destroying your property, cutting out a wall, and they can see the outside, that type of deal. Now, there's a new provision in there for leases that expire on January 1st of 2020, a tenant's refusal to execute a written extension or renewal of the lease on same or similar terms under the original agreement. And there's all sorts of other items that we just covered or that are provided in the code section, such as if you're renting out property to employees as part of their employment and you terminate employment, well, typically under the current law, an employer doesn't have to provide notice to that employee. They have to leave the property because the housing was provided. It's part of their deal, and they're codifying that's just cause as well too. Okay, so what happens if you don't have just cause for an eviction? Well, you're in luck. There are three main reasons that you can do an eviction without cause, and we'll explain them here. If you don't have cause, the long story of it is you will have to provide your tenants a 1 month's payment of their rent for moving assistance, and we'll cover that shortly after going over the grounds for no-fault evictions. One of them is the intent for either the owner or their spouse or domestic partner, child or grandchild or parents or grandparents to move into the property. Now, for this, for you to use this starting on July 1st of 2020, you have to actually negotiate that in your lease agreement. If you don't add that to your lease rental agreement, you can't use this no-fault eviction provision. And that's because of the way they wrote 1946.2. So, in other words, you're going to have to negotiate this term in your lease agreement between now and July 1st of 2020. And just as a side note, if your tenant will refuse to give this to you in your lease agreement, that gives grounds for a fault eviction, because the law built in a provision that this is negotiating a lease agreement on same or similar terms. The law allows for a landlord to do this, and if your tenants refuse to do that, well, you can possibly evict them at that point. Now, withdrawal of the unit from the rental market is listed as a no-fault eviction as well. This is your Ellis Act type eviction, which is in the sense the landlord's right to going out of business. Now, non-eviction control jurisdictions that don't have a method or mode of how you can do an Ellis Act eviction, this would basically be, hey, you give your tenant a 60-day notice, in this case for an example, and you state the reason, look, you're pulling the unit off the market. There's not going to be any regulation that governs how you pull that unit off the market. Now, in more established eviction-controlled areas like San Francisco and so forth, they actually have provisions in place of how you have to do withdrawing a unit off the market. And you have to follow those regulations to the T. The Ellis Act provides provisions that for local cities and municipalities of governing how evictions, pulling out units off the market, can be regulated. So in certain areas, for example, if you do an Ellis Act type eviction, your title may be branded and you have title restrictions on your property for several years. And if the owner or subsequent owners want to re-rent the property, typically those tenants have to be provided the first right of refusal to rent those units again at the rates that they were being rented out for, and so forth. Question that I'll get from my owners and landlords is, okay, I need to do a sale of the property. I want to get out of the rental business. California's too crazy. What do? Can I do this no-fault eviction? Although, yes, I mean, if single-family home, you could say, hey, you're pulling that unit off, going out of business, you're trying to sell it and so forth. That might work. On a multifamily property, sometimes my owners ask, hey, can I just do that to one unit? Let's say it's a fourplex, and I want to pull one unit off, but there's three other units in play. Don't think you could just withdraw one unit from your multifamily building, because the court's going to see right through that. Well, hey, why didn't you evict the other tenants too if you're going out of business? Why is that one unit getting evicted? Looks like you're picking on that one particular tenant. And, so, yeah, don't think you can do that, okay? Okay. Also, 1946.2 also has a provision for the owner complying with any one of the following items. Government entity or court entity ordering the landlord to vacate the tenants by order of that entity. Such as like a court order, or if like the city red tags the property requiring the tenants to vacate, that's going to be covered, or an owner's intent to demolish or substantially remodel the residential property is covered. So with that saying, let's cover what substantially remodel is defined under the code section. And the code section has this long-winded definition of what substantially remodel means. Okay, I'm just gonna cut to the chase here. This doesn't mean, hey, I needed to repaint my unit and so forth, so that's substantially remodeling. No, the code basically states, hey, the repairs, the items can't be done with the tenants in possession, and it's going to require that the tenant vacate the property for at least 30 days. Okay, let's cover some examples of that, what that may be. Okay, let's say, for example, a total substantial remodel is probably going to be gutting a unit due to fire damage throughout the unit. A fourplex catches on fire. It damages the top units. The fire totally destroys the top units, but the water goes into the bottom units as well, completely causing mold and stuff to grow in the entire unit. That's probably going to be a substantial remodel. Removing a hazard and completing work that's going to take longer than 30 days, such as you've got like extensive asbestos removal, like in this fire situation. Well, you're going to have to get a hazmat team together. The tenant cannot live there. The property is going to be red tagged by the city, for example. Items that are probably not going to be substantially remodeled or in the substantial remodel exception are going to be remodeling a single bathroom or even a kitchen. Under the California habitability law, yes, you have to have a work operating kitchen and bathroom and so forth. But if the work isn't going to take more than 30 days to complete, and I mean 30 reasonable days for an average contractor working under prudent circumstances and so forth to complete the work. Your handyman, your lazy handyman, good for nothing handyman that can't get to your unit to fix a stove or something is not going to qualify as something that's going to take 30 days. I know it's hard to get hard work from contractors these days, or working on these fire damaged buildings throughout California and so forth, but we're talking about reasonableness here. So again, don't think you can get away with, hey, it's going to be inconvenient, or we're going to have to work around the tenant schedule and so forth, and I want to do an eviction just because of that, or the tenant's being a pain in the butt. That's not going to work. Okay, just a warning for you. Okay, so I mentioned earlier that landlords that do a no-fault eviction for one of these three reasons are going to have to cough up some cash for relocation assistance. And that's going to be a minimum of 1 month's rent. And the statute says you can do it either one of two ways. Either you can make a direct payment to your tenants for the move-out assistance, or you can waive last month's rent, basically. So if you do the direct payment route, you have to issue the payment within 15 days of the owner's notice of election of providing that assistance in that form. If you elect to waive the last month's rent, then you have to do so in writing and state that the rent's going to be waived and that no rent's going to be due for the final month of the tenancy. In all cases where rental assistance is provided and the tenant holds over and you have to do an eviction to get them out, you can collect your relocation assistance in an eviction judgment. Here's my 50 cents about it. You probably want to waive the last month's rent. You know why? Anyone that's done an eviction before is probably going to tell you this. Look, eviction judgments are only worth the paper that they're printed on. The most valuable thing in an eviction judgment is getting actual possession back of the property. Are you going to get your past due rent and your eviction move out assistance through that judgment? Probably not. The probability becomes very low here. So if you make a direct payment and your tenant doesn't leave as required under the law, which in a lot of times that does happen when you issue a termination notice, you're just out that money. And yes, you can get it in a judgment, but it's just like a double ouchie, basically. You just lost the money you provided, and now, you got an eviction judgment that's uncollectible. So you might just want to waive last month's rent. It is what it is at this point. Thank your legislature for that gift. Okay, new highlights. Now, the code provides new restrictions for curable tenant violations. If 1946 applies to you, you have to be aware that the code actually provides for 2 3-day notice periods. Let me explain to you. So before 1946 came into effect, or before it comes into effect in January here, if your tenant violated a term of the lease, let's say they're smoking on the property, what you'd go do is issue a 3-day notice to perform, telling your tenant, hey, your lease prohibits you from smoking. On such and such date, we observed you smoking at the premises. I'm giving you 3 days to stop smoking on the premises, or else we'll evict you. And if the tenant continued to violate the lease agreement, well, you would go file an eviction complaint after those 3 days were up. Now 1946.2c is telling you that in addition to the 3-day notice to perform, if the tenant doesn't cure the issue, you have to issue a 3-day notice to quit, where you have no opportunity to cure. In a nutshell, it's giving the tenant 2 3-day notice opportunities, or 6 days to actually start the eviction process. And as of September 1st of 2019, for all those that follow us here, you can't count weekends or court holidays anymore. So that means the tenant has 6 business days now to stay in the property if they're going to violate a term of the lease and continue to violate it after a warning from the landlord and the 3-day notice to perform to stop that behavior. Wow. Okay. So, any potential problems with this new fancy civil code section? Well, under the new civil code section, the code states that all tenants must be given a 3-day notice for all curable violations. And for all my sophisticated owners and landlords that have been doing this for a very long time, the classic non-payment of rent case, for example, that is actually technically a curable violation, because in a sense what you're doing in a 3-day notice to pay rent or quit is telling your tenant, hey, my friend, you are late on your rent. The rent is due. Here's the amount. You got 3 days to pay it, and if you don't pay it or give me the keys back, I'm going to go to court and get an eviction judgment against you because you're violating the term of the lease. But our fancy 1946.2 Civil Code only references Code of Civil Procedure Section 1161.3, which is the section for performance of a material term violation of the lease agreement. And for all my fancy lawyers out here that do evictions for a living, traditionally under case law, evictions for non-payment of rent are curable. Rent are curable. Curable notices that can be cured. So, but they don't define a non-payment of rent as a curable item, although traditionally under the law it is. Let's just look at the fancy code section itself, and it basically just states for residential real property issues a notice to terminate a tenancy for just cause that is a curable lease violation. If you go back to our slides before, just cause includes non-payment of rent, and it's a curable violation. I have to issue a notice to perform, but that's not specifically non-payment of rent, although it is a just cause for eviction, and it is a curable violation. So that kind of causes some confusion. Do I have to do the 2 3-day notice deal? Here, on one hand, I'll play devil's advocate here. On one hand, my argument for against issuing 2 3-day notices on the non-payment of rent case is saying, well, the legislature is referencing curable breaches of the rental agreement. Your typical no smoking, no pets allowed, that type of section. Non-payment of rent is governed under Code of Civil Procedure 1161.2. It doesn't say that, so I don't have to comply with it. But it is a curable violation under case law, and it is a just cause for eviction under 1946.2. So probably my best recommendation for the landlords that want to be cautious, you're probably best just to comply with issuing 2 3-day notices. You issue a 3-day notice to pay rent or quit. Reference, hey, if you don't pay the rent on time, I'm going to issue you a 3-day notice to quit under 1946.2. I'm sorry, that code section's off. So it's 1946.2. We'll get that cleaned up later on. Because guess why? Because if a judge disagrees with you that you failed to comply with all the terms of 1946.2, guess what happens? Your notice is void. And guess what? A void notice equals no eviction. Because under California law, you must have a valid termination notice. Wait the requisite amount of time for that notice to expire before you can go into court. And there's a bunch of cases on point that say, hey, look, if the notice is bad on its face, it can't sustain a cause of action for unlawful detainer. That's a fancy word for saying you can't do an eviction in this court. You're going to have to start over and try again. Okay, let me get off my soapbox there. So, with this new fancy eviction control, there are going to be some new disclosures for landlords to tell their tenants whether or not 1946.2 applies to them or not. And we'll go over those right now. So, for owners that are subject to the new eviction control statute, by pretty much any new lease that's entered into as on or after July 1st, 2020, you're going to have to give tenants the disclosure on the bottom below that's in parentheses that, California law limits how much rent can be increased and limits how you can do an eviction. Okay. Now for existing tenancies that are in play, I'm sorry, I hit the mistake. For existing tenancies or tenancies that are going to renew or that were entered into before July 1st of 2020, you have to provide this disclosure to your tenants by August 1st, 2020, either in the renewal of the lease, an addendum to the lease, or you got to provide written notice informing tenants that California law, this California this fancy 1946.2 statute, it's going to apply to you, and you have all of these protections, and you have to give the disclosure verbatim as in the quotes below. Okay? Now, for owners that are exempt from 1946.2, you also have a disclosure requirement, and it's going to follow the same line of the same mechanics as disclosing to tenants that they are protected under the new statute. You have to say that you are exempt under the statute. So for new tenancies after July 1st of 2020, you got to tell your tenants that, hey, your property is not subject to the rent limitations implied, by 1947.12 and the eviction protections statute 1946.2 doesn't apply to you. And then for tenancies that are entered in before July 1st, 2020, you have until August 1st, 2020 to either give your tenants a written addendum in the renewal of the lease, or notice that, hey, the property is not subject to regulation as stated in the quotes below. Okay? So, how long are these provisions in place for? The code section says July 1st of 2030. And the whole rationale behind that was the legislature wanted to study if this helps the California housing crisis and so forth. But guess what? I'm a cynical type of guy. Any type of sunset provisions, which this is here, usually are made permanent by the legislature. It kind of gets people adapted to the law, and then they do another act in the legislature, several years from now, saying we need to make these provisions permanent and so forth, and they're probably not going to go away. So sorry, I hate to be the cynic in the room, but the way things are going nowadays, depends on what side of the fence you sit on. My view is, you're making complying with the law more and more difficult, and it's difficult as it is right now to keep up with the laws, and it's even hard for lawyers to keep up with all this legislation. So that's just my view. That's just my 50 cents. You take it for what it's worth. And so if you have any questions regarding this video, please feel free to give us a call at any time. There's our number right there, and we'll have links to our website and so forth. I'm hoping this video kind of helped you a little bit, even if it is, it's somewhat confusing. The statute is very confusing in its own right, and even for the best of attorneys, it was kind of difficult to navigate. So I hope this helps, and we'll see you soon. All right, take care.